Good morning. It's Wednesday, November 12th, and our client was detained at the end of September in Chicago. And today, a federal judge ordered his release within 5 days or for the immigration court to hold a bond hearing. So let's talk about what happened. As you may know, at the beginning of September, Board of Immigration Appeals case came out essentially interpreting a statute so that any person detained in the United States would be subject to mandatory detention unless they entered with a visa. This goes against longstanding precedent and even their agency's interpretation and application of the statute. So what ended up happening is people were detained and placed in removal proceedings without ever being able to seek bond. This means you could be detained for several months until you get your final bond hearing. This has never been the case in the essentially 15 years I've been a practitioner. ICE has never interpreted the law to mean this. The BIA has never held that individuals in this category would not be eligible for bond, but lo and behold, that is what happened. So then what? Practitioners such as myself started to sue in federal court, saying that this is an unlawful detention, that they have no authority, and essentially that the BIA opinion was incorrect, their analysis of the statute and their application. And that's what happened in this case. Our client was detained at the end of September. They retained us shortly thereafter, and about 2 weeks ago, we filed a motion in federal district court where he's detained. And today, 2 weeks later, after the government filed their reply and then we replied to their response, the judge issued her order stating that our interpretation and many other immigration attorneys' interpretation of the law was correct, that individuals who'd been present in the United States despite not having entered with inspection were not subject to mandatory detention under the statute that the government was citing, and that as such, he must be released or he must be given a bond hearing to determine the terms of his release within 5 days. So I share this story because it does take a little bit of patience. It certainly takes energy, money to even get a bond, right? But it can be done. Don't give up hope. If you have family members, you know people who are being detained, you want to make sure that you are going to organizations who can file writs of habeas corpus for you, or you're finding attorneys barred in the jurisdiction where the individual is detained who can file these writs for your loved ones and your family members. It, like I said, does take patience. I've walked the family through it. I told them from the beginning, from when we file to when we get the bond hearing could be 3 or 4 weeks, and that we're pretty much right on track because we're going to have the bond hearing within 5 business days. So essentially it'll be 3 weeks from start to finish. It is uncomfortable to be detained, but if you have a plan and your family members know the plan, I think that the mental battle is the hardest battle, and knowing that there is an avenue for release is super important. So please share this video because, again, I think the mental battle is the most difficult, not knowing how long it's going to take. I've been telling my clients on average around 3 weeks to get that bond hearing after we file that petition for writ of habeas corpus, and this case is proving to be right on track with that timeline. But I had to share the exciting news. We are happy for our client. Our next step is actually doing the bond hearing, but based on the facts, I'm very optimistic about him being released after the bond hearing.